That is absolutely good. This is someone. Yeah.
For judgment, item number 1.
For the reasons stated above, the detention order dated 9/5/2025 has been found unsustainable in law. It is therefore set aside. Consequently, the order dated 12/8/2025, whereby the detention order dated 9/5/2025 was confirmed with extension up to 12/11/2025 with effect from 13/8/2025 is also set aside with the detention order dated 9/5/2025. The writ petition is allowed to the extent indicated above. As a corollary, it is ordered that the detainee is to be released forthwith if he is not required to be detained in any other case.
Much better.
For judgment, item number 2.
Summing up, for the findings reached at and the regions assigned after the discussion made above, this court is of the view that the detention order dated 2024 cannot be upheld. Consequently, the confirmation orders passed subsequently on 19/3/2025 and 26/2025 are also set aside along with detention order dated 20/12/2024. Yes,
Lordship, I beg to mention item number 20, hearing item number 20.
item 20.
20. Lordship, this matter will be listed on after Puja,
Okay,
9
9th.
October.
Okay, on the prayer of Mr. Im Chung, Learned Traditional Advocate General, Nagaland Quarter State Respondents, release the case on. You appeal for a petitioner? Okay, release the case on 9/10/2025. Mr. You are for? Mr. and petitioner?
I'm from petitioner,
Miss,
Rebecca.
okay, learned counsel for the petitioners and Mr. Mohajami, learned counsel for the respond number. And for sake of Kote,
11.
11, respond number 11 are present. Full stop.
May it please your lordship, I beg to mention hearing item 21.
Okay, Miss. So you are for the petitioner,
I'm for the respond number 3.
respond number 3. Okay, Mr. Mohajami, learned counsel for the petitioner is present. Miss so learned counsel appearing for the respondent number
3.
3.
Kindly this matter be listed after Puja break.
Okay, when? Immediately after puja or? In the week commencing from 13th? And Miss so and state councillor present. Has prayed for listing of the case. After 2 weeks, first of, as the president proposed by the Learned Counsel for the other sides, lays the case on a date in the week commencing from 13th of October. 13th of October.
Must be given with the item number 10. Lordship. Five for respondent number 2 and 3. This
Okay.
we have to file that during opposition 2 weeks maybe.
Miss,
I'm for the petitioner, lordship.
your name please?
Abi.
Abi Kent.
Yes, lordship.
Learned Counsel for the petition is present. Mr. Mohajami, Learned Counsel for the respond number 2 and 3. Was paid for and is granted 2 weeks time to file an affidavit in opposition on behalf of the state respondents. Raise the case accordingly after 2 weeks.
May it please my lordship, as per the liberty granted on 22/9/2025, lordship, I have filed a writ petition yesterday. However, it's not listed today, so I may be allowed to move it unlisted. Also, lordship, IA in writ petition 162/25 also.
That may be listed tomorrow.
IA, lordship, it's only the writ petition.
Yes, any other
Yes,
mention?
your lordship. Lordship, I'd like to mention item 4. The DC verification is still awaited, so we'll pray for 3 weeks, your lordship.
Oh, some verification ordered.
Yes, your lordship.
Okay, we'll take up when the matter comes.
Okay. Now, please mention item 6.
6.
Yes, we're yet
Yes.
to receive instructions, so we'll pray for 3 weeks, your lordship.
Which part of petition is 6?
I've taken the consent.
Okay, Mr.
And no comment.
I am wrong. Then State Council. The non-government advocate Nagaland appearing for the state respondents has prayed for and is granted. How much time? Mr. Longkumar, how much time?
Your lordship,
How much time?
3 weeks, your lordship.
3 weeks time. to file a counter affidavit. Yes,
For the respondent number 6,
Mr. Jamir.
I filed my counter affidavit this morning.
Okay, Mr. I. Jamir.
Worship.
Learned counsel for the respondent number 6 has submitted that a counter affidavit on behalf of the respondent number 6 has been filed today. Post up. As before that, Mr. Longkumar has submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Place the case after 3 weeks.
Your Lordship, I have a similar prayer for item 8. Yet to receive instructions, so prayer for 3 weeks, Your Lordship.
Pakiri Chandu.
I have instructed Mr. Malord if may allow me. On the sale of Muslim, I prayed for the interim order, but Zulu court infected. The prayer for interim order should be considered for the next one date. Since I'm praying for appointment on that basis to the vacant
Okay,
post.
let the matter called up.
Your Lordship, lastly, I want to mention item 22.
Yes.
I'm to file an additional affidavit. And I've sent it for vetting, so 2 weeks may be given, Your Lordship.
Yes. Learned counsel for the petition is present. Mr. M. Longkumar, learned government advocate Nagaland has submitted that the additional affidavit to be filed has been sent for vetting. So he has thus paid for listing of the case after
2 weeks, Your Lordship.
2 weeks.
In the meantime, please let me continue.
2 weeks. Mr. Forte, you are for?
Fine.
Okay. And the learned counsel for the petitioner and the respondent number 5 are present, huh? At the top. Okay, the prayer is allowed. Place the case after 2 weeks. The interim order passed earlier shall continue till the next event.
My pleasure, Lordship. Lordship, I beg to mention item number 5. Lordship, kindly grant 2 weeks time to file affidavit in reply.
Affidavit in reply.
Lordship,
You are for the petitioner.
no Lordship, for the state, filed by the petitioner, Lordship.
Huh?
To the affidavit filed by the petitioner, Lordship.
Petitioner has filed a petition.
Or the Lordship, my pleasure, Lordship, if I've sent for waiting, so if.
Your affidavit in opposition.
Lordship, I've sent for waiting,
Your affidavit in opposition
Lordship.
from for the state respondents.
Lordship.
Okay. Miss, your name please, madam. Okay, Jamil Learned counsel for the petition is present. Miss
Pichano.
Pichano, Learned Government Counsel, Advocate Nagaland, has submitted that the affidavit in opposition we file on behalf of the state respondents, has been sent for vetting. She has thus paid for listing of the case after
2 weeks,
2
Lordship.
weeks in order to file the affidavit in opposition within 2 weeks time. So stop. Under prayer is allowed, release the case after 2 weeks.
Lordship, item number 7.
Hmm.
If sometime will be granted, Lordship, to file reply.
Government reply.
Lordship.
Okay. Miss.
Sipu.
Yes, Learned counsel for the petition is present. Miss Pichano, Learned Government Advocate Nagaland has paid for. How much time you need?
Lordship, 2 weeks time, Lordship.
And is granted 2 weeks time to file affidavit in opposition on behalf of the state respondents. List the case after 2 weeks.
Lordship, I also like to beg to mention item number 12. On
Okay.
behalf of Libika. Lordship, she's here to receive instructions, so kindly list this better after 3 weeks.
Miss Learned counsel for the petition is present. Miss Pichano, Learned Government Advocate. Appearing for Miss Libika, Learned Government Advocate who is handling the brief. Has submitted that necessary instructions are yet to be received to file the counter affidavit on behalf of the state respondents. a prayer is made to release the case after 3 weeks in order to obtain necessary instruction and file counter-affidavit on behalf of the state respondents. The prayer is allowed, release the case after 3 weeks.
Lordship, similar prayer with item number 13.
The previous one was 12.
12, Lordship,
Okay,
and similar prayer with item number
Same.
13.
same. 12, 13, same.
Lordship, item number 14,
Yes,
on behalf of Tipabon. His shadow received instructions, so can you miss this letter after 3 weeks?
same instead of Thibapong, Livika Thibapong. Miss
Yes, Lordship,
Jimomi, Land Council, but a petitioner is present.
interim order 29A.
Okay, the interim order
Continue.
passed earlier shall continue till the next day.
Obliged, Lordship. Lordship, I also like to beg to mention item number TV3 on behalf of Vizimo. Lordship, can you list this matter after 1 week?
Chima. Yes, Mr. Longchair. Mr. I, Shimti Longchair, Land Council, but a petitioner is present, and Miss
Lordship, I'm for respondent 9.
9. Your,
Respondent number 11,
yes, your name,
Renbody.
Land Council, for respond number 11, and
10.
9 and 10.
9 and 10 are present. Miss Pichanov, same. Miss Pichanov, Land Government Book Nagaland. On behalf of Mr. P. Jimomi, Land Government Book Nagaland has paid for listing of the case after 1 week. As the prayer is not objected to by the Land Council for the other sides, the prayer is allowed, list the case after 1 week.
My
Lordship, I beg to mention item number 1. Kindly allow the matter to be listed after.
One, you wait for your turn.
Yes, Lordship, I beg to mention item number 9, Lordship.
9.
Yes, Lordship, I'm yet to file my reply. Another 1 week time may be given, Your Lordship.
Yeah, Miss
Mr. Your Lordship.
Esther. Land Council for the petition has paid for and is granted 1 week time to file an affidavit in reply to the affidavit in opposition filed by the state respondents, Mr. Imsong, and additional advocate general, Nagaland. Is present and has submitted that he has no objection to this prayer.
Lordship,
Release the
interim-
case after a week.
Lordship, there's an interim in the IA as well as in the writ petition, which may be extended, Your
Okay,
Lordship.
the interim orders, wherever passed, say continue till the next date of this.
Much more.
Bless your lordship. Lordship, I'd like to mention item 15.
15, yes.
I am for the state here. Now, I have completed the counter-affidavit and it is sent for bidding. So,
Okay.
let this matter will come out in 2 weeks.
There's an interim. I need to for the lordship. In fact, lordship, observation was made on the last one.
Anyway, it is 16 serial will take up. We'll take up, we'll look at, allow the prayer,
Lordship.
interim will continue.
Lordship.
Let the file be here. Hardly it is 16 serial. You can wait that.
For motion from the supplementary cost list, item number 25.
Okay. Yes,
May it please your lordship. Lordship, the petitioner hearing is seeking for regularization of her service. As she has already completed 30 years of service and she is enjoying skill pay. And she has fulfilled
heard Mr.
SOP.
SOP. Learned Council for the petitioner and Miss Pichano. 1 minute. Learned the government advocate for all the respondents.
Lordship,
Yes, all the respondents. Yes.
This matter can kindly be disposed of today. My lord was pleased to dispose of a similar matter in WPC 221 of 2024.
Where is it? Give it. Yes, madam, what do you say?
Lordship, I have no objection to the disposal of the representation, Lordship.
Hmm? Go through it. If it is possible to be disposed of, we'll dispose of. Let her go through it. We'll take up after some time.
Time, my lord. Obliged, my lord.
Yes.
For motion, item number 26.
May I please, Your Lordship?
Yes.
Your Lordship, here the petitioner is aggrieved by the restraining order which was issued to him by the Deputy Commissioner of Mokchong, directing him to stop excavating.
We can issue notice at this stage. Restraining order is of 2023,
Yes, Your Lordship.
2.5 years.
Your Lordship.
We'll issue notice.
Yes, my lord.
Your
Where is
Lordship,
the impugn order? Page,
next year, 8, Your Lordship.
page.
No.
You have not kept the impugn order marked.
Pardon?
You have not kept the impugn order marked. You are looking for the impugn order in the court. Page 94 perhaps.
Page number 66, Your Lordship.
66.
That copy is page number 67, Your Lordship.
67. Have you made Power Grid a party or not?
Yes, Your Lordship.
Okay.
The respondents 6 and 7, Your Lordship.
My lord, since the restraining order is very specific and clear for the safety of the public. So let the notice go first.
Yes, we are only issuing notice
Yes, ma'am.
because if it is a transmission line,
Yes, ma'am.
then there is a law, Telegraph Act and Electricity Act.
Yes,
that
ma'am.
5 feet this side, 5 feet that side, or 5 meter that side, 5 meter this side, there should not be any activity.
It cannot be done very easy.
But whether his land is beyond that or
Yes.
inside that, that is a matter
Yes.
only Deputy Commissioner and
Public
Power Grid.
is more important.
Power Grid, they can only reply.
Yes.
Heard, Miss
Mr. Jamir, Your Lordship.
MC Jamil, learned counsel for the petition, and Mr. L.T. Sanctum, learned additional advocate general, Nagaland, for the response number 1 to 5. 1 to 5? Post of the petitioner.
Lord, may I please, Your Lordship? Let the interim prayer may be heard in the next return.
No chance. 2.5 years. This is not a matter which can be, interim order can be passed without hearing the other sides.
State respondent number 1 to 5.
Because 5 and 6 is also involved. Heard, the petitioner has approached this court by the instant writ petition to assail a restraining order dated 18/5/2023. Post of para. In the restraining order issued under the hand of the Deputy Commissioner, Mokok Chang, within bracket response number 3, comma, it is inter alia mentioned that a complaint was received from the office of the respondent number
6 and 7.
6,
6 and 7, Your Lordship.
6 and 7 on 2/5/2023 to the effect that a landowner was carrying out stone quarrying activity near page 67, near tower location 152 of 220 kV double circuit Morioni that's Mokok Chang transmission line in CTC area, and as a result of which the tower has become critical and prone to had become critical and prone to collapse. Full stop. The petitioner has stated that because of the restraining order, he has not been able to carry out any activity in his plot of land, which is near
Near the tower.
to the tower mentioned in the restraining order. Post of before that, last line of the previous paragraph. The restraining order has been passed, taking into account the criticality of the tower and the response number 3 had directed the landowner to restrain from carrying out stone carrying activity near the said tower till further direction. Post of. Then the petitioner is raised. So the petitioner submitted that since 18/5/2022, the respondent authorities has not reviewed, modified, recalled the restraining order in spite of repeated approaches by the petitioner. Issue notice returnable 4 weeks.
May I please, Your Lordship, for respondent number 6 and 7, if notice may be issued through registered agent.
True?
Registered agent. Registered post.
You wait
6 and
to, you should wait for me to complete the order. Don't interrupt. If something is to be added, you add, please. Don't lose patience at the drop of a hat. As Mr. Sanctum has appeared and accepted notice on behalf of the respondent number 1 to 5, issuance of formal notice to the said respondents is dispensed with. The learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with annexes to Mr. Sanctum within 3 working days from today. The petitioner shall take steps for service of notice of the respondent number 6 and respondent number 7 by registered post with AD within 3 working days from today. This is the case after 4 weeks.
For admission, item number 1.
Yes, you were submitting something on item number 1.
Yes, Your Lordship.
Don't make mention of item number 1 at mention time. Right? Yes.
Your Lordship, kindly allow the matter to be listed after Turga with vacation.
Mr. Jamir, you are
I'm for respondent 6.
6,
6 for.
private respondent.
Yes, for.
Okay. You want to file affidavit in reply against the affidavit in opposition of the private respondent number 6?
Yes, Your Lordship.
Because you have no. You have already filed affidavit in reply to the affidavit in opposition to respondent number 6. You want reply against what? Government advocate?
No, Your Lordship will not reply.
Huh? Affidavit, does the affidavit opposition on behalf of the respondent number 5 has filed already. Respondent number 6 has filed affidavit.
Yes.
Affidavit in reply to the affidavit in opposition of the respondent number. Let me see, something wrong.
Your Lordship,
1 minute, let me check. You have got yourself confused. 6 has filed. Six has filed. This is 1. All have filed.
Yes, for.
All have filed. All have filed. You have filed replies,
Yes, sir. I am not sure.
then why?
Additional affidavit.
Additional affidavit. Miss Learned Counsel for the petitioner, Mr. Long Kumar, M. Long Kumar, Learned Government Advocate for the respondent number 1 to 5, and Mr. Mohan Jamil, Learned Counsel for the respondent number 6 are present. Ms. So-and-so, Learned Counsel for the petitioner. As why? Procedure says that once read petition, affidavit in opposition, and affidavit in reply, the stage of pleading is over unless you seek leave. Supreme Court has laid down the procedure. Why you need additional affidavit?
Your lordship,
Or what? Any subsequent development?
your lordship, we're waiting for some instruction from the petitioner for clarification. Or something.
We'll say only that. Because leave is to be sought to file. Otherwise, they will again file. It will go on. Miss So-and-so has sought listing of the case after,
Puja vacation.
okay, 2 weeks in order to obtain certain clarifications for the petition, from the petition. First of, okay, as reply is not opposed by the learned counsel for the respondents, release the case after 2 weeks.
Item number 2.
Bir Moni Singh.
May it please your lordship. Your lordship, appearing on behalf of each for our lordship. Lordship, the consolidation disposal kindly list the matter of the 2 weeks, lordship.
You are Mr.
No.
Your
appearing
name? Your name?
To Shitumchen.
My lord,
Hmm.
that case, three weeks time may be granted.
To see Tenjam.
Yes.
Learned counsel has appeared on behalf of Mr.
Each for our.
H. Borua, learned counsel for the petitioner. Mr. L.T. Sanctum.
Lordship, for the respondent number 5, I'm appearing on behalf of Mr. Joshua Shafiq.
Okay, you also file your affidavit then within 3 weeks' time. Learned Additional Advocate General, Nagaland. You were assisted by anybody?
We, Zimomi.
Learned Government Advocate.
And
For the respondent number 1. You were appearing for.
Respondent number 5, I'm appearing on behalf of Mr. Joshua Shafiq.
Okay, 1.
my lord, I'm for respondent number 1.
Okay, respondent number 1 to 3. Okay. 4. Parties have been changed.
Yes, ma'am. He appeared-
No, he is from Accountant General, I think. Respondent number 4 is Commissioner and Secretary to the Government of Nagaland Personnel and Administrative Reforms Department. They have filed a fresh
Yes, ma'am.
memo of parties,
Yes, ma'am.
1 to 4. And Mr.
I'm for respondent number 5,
Name,
Donato.
Donato, Learned Counsel for respondent number 5.
Appearing on
Have-
behalf of
have-
Mr. Joshua Shafiq.
Huh?
I'm appearing on behalf of Mr. Joshua Shafiq also.
Appearing on behalf of Mr. J. Seki. For the respondent number 5, have prayed for and are granted 3 weeks'
My
time.
lord, I'm assisted by Sipong Lambacha.
I prayed for and are granted 3 weeks' time to file their respective counter affidavits. Post of this the case of the 3 weeks.
Item number 3.
Please, your lordship,
Yes.
lordship, we have received the affidavit today, so sometime it will give.
Oh, file.
through.
You have filed.
I filed yesterday.
Okay.
Sometime it will give it to go through, and if necessary, we will apply.
Miss
Rebecca.
Rebecca, learned counsel for the petitioner. State Council Pichano. Learned government advocate, Nagaland for the respondent number 1, 2, and 3, and Mr.
James Nimot.
Learned counsel for the respondent number 4. Are present, Mr. So-and-so, learned counsel for the respondent number 4 has submitted that affidavit in opposition on behalf of the respondent number 5 has been filed yesterday.
This morning.
We take, okay, today, we take copy to the learned counsel for the petitioner. Post of Ms. So-and-so, learned counsel for the petitioner has submitted that she has received a copy of the affidavit in opposition of the respondent number 5 and has paid for how much time?
2 weeks.
3 weeks. 3 weeks time to go through the same and to file affidavit in reply, if so advised. Post of the prayer is allowed, release the case after 3 weeks.
Item number 4.
Mr. Lordship.
Yes.
Lordship, I was seeking for some time to receive the verification report from the DC.
M. Long Kumar,
Yes, Your Lordship.
petitioner is not there. Okay, wrongly named. Okay, there is no representation on behalf of the petition today on call. Did they mention at 10:30? No. This item,
I mentioned that.
you mentioned.
Yes, yes,
Counsel for the petitioner was
yes.
present.
yes.
Okay, the learned counsel for the petitioner is present. Mr. M. Long Kumar, learned government advocate. Nagaland. Has submitted that the Deputy Commissioner Mon, yes,
Yes.
Ah.
One.
what is the status?
It's still awaited the verification report.
Who is, you are awaiting or Deputy Commissioner is awaiting?
We are waiting Deputy Commissioner's report.
He has completed,
Not yet, Your Lordship.
huh?
It's still in the process.
Has submitted, comma, on instruction, comma. The Deputy Commissioner Mon is in the process of finalizing the verification report.
Lordship.
First of, as the verification report has not been forwarded till date, comma, Mr. Long Kumar has paid for listing of the case after
3 weeks, Your Lordship.
3 weeks.
Lordship, Jason intern,
Your Miss
Rebecca.
Rebecca, petitioner present, huh? By the top. The list the case after 3 weeks, the interim order passed earlier shall continue till the next date of list.
Obliged, Your Lordship.
Item number 8.
It not mentioned. It mentioned or not mentioned?
I mentioned, but you said it to.
Okay,
Last list.
okay.
But the petitioner seems to be out. He was present in the morning.
Okay.
I spoke for some 3
Okay.
weeks.
3 weeks. Who was the petitioner of council?
Fucking,
Bakiri Chandu.
yes.
Oh, where is he now?
It was here.
He was stopping me from passing any order. Yes, we are waiting for you. Yes, what was the previous order?
The order dated,
Oh, that is 11/4, and that was not renewed, sir.
my,
That was not renewed. 11/4, right? Now thereafter much water has flown through river Sathe. 6/5, 2/6, 24/6, 7/8. You have not renewed the prayer. I thought today is the returnable date. You were pressing it. You did not press it for last 6 months. Then you file your affidavit already.
Yeah. 3 weeks.
Much water has flown now. For you also.
But We have not
So
received
you
instructions
please
so far.
ensure that your affidavit in opposition is filed. Okay, Mr. Paki Richanwood, Learned Counsel for the petitioner is present and has pointed out has pointed out that after issuance of notice on 11/4/2025, the state respondents despite being granted time on 5 occasions,
Yes, ma'am.
have not yet filed their counter affidavit. Post. Mr. M. Longkumar, Learned Government Advocate, Nagaland, has submitted that the instructions are yet to be received to file counter affidavit. Post. Para. The state respondents have already been granted time to file their response since issuance on 5 occasions since issuance of notice on 11/4/2025, therefore the state respondents shall ensure that its counter affidavit is filed within 3 weeks' time. Release the case after 3 weeks.
Obliged, Your Lordship.
Item number 11.
Yes.
Mr. Lordship, Lordship, we have received the instruction that with regard to petitioner number 3 and 4, the clearance was given by the PNR, but for change of name. But with regard to change of date of birth and father's name, the petitioner has to submit the documents. As and when the petitioner submits the documents, it will be uploaded in the PIMS. Then only the salary will be released to them. Then with regard to petitioner number 1 and 2, Lordship, till now they have not submitted the documents for which we could not get the clearance. So Lordship, in that case, I pray that 3 weeks time may be granted to us so that we file our affidavit.
Lordship, here I'm praying before this honorable court for non-payment of salary since March 2021. It's been 4 years and I've been denied my rightful salary.
2021.
Yes, Lordship. And
There is a long order previously.
Lordship, as per the last order,
Grant 1 minute. What is R1 category?
Lordship, R1 is category are those who has the anomalies in the names, the date of birth. So only when they come to RA, that is the category where the details match with the Aadhaar card, Lordship. A is the category. So here, Lordship, the petitioner undergone the verification process because the appointment order name, the name of the petitioner registered in the PIMS, the date of birth registered in the PIMS, everything is different from what the petitioner is asking. So Lordship, unless and until they provide the documents for change of name duly signed by the first class magistrate, Your Lordship.
How many petitioners are here?
4.
4.
Yes.
They are work charge level, skill
Work
level,
charge.
on fixed pay.
yes,
Yes.
Since March 2021.
21.
If they were receiving fixed pay, what was
Yes.
the problem? Suddenly stopped?
Lordship, but whether they are genuine work charge or not, only when they are genuine, only we could pay their salary. So now the genuineness of the holding that fixed pay ward charge is under question. So only when they submitted all the documents and it is updated in the PIMS, then only we can release the salary. Lordship.
Here, there were 6 of them who were appointed by common order. My annexure A, page 9. Type copies at page 10. Out of 6, 2 of them, they are getting their salary. And the rest 4 of them, the petitioners, they are deprived since March 2021.
Okay.
And
Heard,
also, as per
Mr.
Last order. As per the last
Okay,
order,
heard, Mr.
is single.
And Council for the petition and Ms. P. Sukril and additional.
Let me submit. As per the last. order,
We'll hear you again. Let me be clear about the case. Grant additional Advocate General Nagaland for the state response. Post of the petitioners, foreign number, have claimed that they were appointed as work charged skilled labor at fixed pay by common order, appointment order dated 23/5/1991. And since then, they've been working in the establishment of the executive engineer, PWD, within bracket, RNB, Longlang Division, Longlang, full stop. The petitioners have approached this court on the ground that since March 2021, they have not been receiving their pay. Full stop. Okay. And what is this PIMS? Personnel?
I don't know the information.
Information management system.
Yes. Personal
Right?
information management system. Lordship.
Okay. So this is their details are to be uploaded.
Uploaded. Yes. Yes. So
Their details are not yet uploaded.
no, they have received the PIMS. They have got the PIMS, but the PIMS never tally with the appointment order with the date of birth, Lordship. So Aadhaar also. So they have to submit all the documents so that we could upload it. And if we found that they are genuine, then only we can release the salary.
Now you say something about 1 and 3.
With regard to petitioner 1 and 2, they are yet to submit the details, the correct details, for which we could not get the clearance from the PNR. With regard to petitioner number 3 and 4, clearance for the change of name has been granted by the PNR, but they have to again give the details of date of birth and father's name.
Okay.
There are so many anomalies and
The
discrepancies.
state government, in which year it was introduced, PIMS had introduced a new system called Personal Information Management System, PIMS, wherein all the requisite data of employees working in various departments of the government of Nagaland are to be incorporated and are to be incorporated. Post of the PIMS, the necessary data of each employee, necessary data of each employee is uploaded in the portal.
Yes.
Of the PIMS portal. Post of non-release. So what is in the previous order, 2 different stands were found to be taken by
Yes.
executive engineer and deputy secretary.
Yes. So, Your Lordship, the clearance is that this is for the order, the letter which was given by the PNR was given by the PIMS. PIM branch.
PNR means Oh, P.
Personal and if,
Okay, okay,
yes,
P and AR.
yes, PNAR, yes.
Uh.
So that letter was submitted by the PIMS cell, PIMS branch. Under the PNAR, there are 6 branch, Your Lordship. So for
Don't go to the offices, please tell me simply.
because there is no Lordship, what the PNR is saying is that
What
once,
are the requirement the petitioners now have to do?
yes, they have
Tell
to
me.
give, Lordship.
Tell me. Petition number 1 and 2, what is the requirement on their part?
Okay, Lordship, the requirement.
Plain and simple.
Yes. The requirement is that for the change of name, for the date of
There
birth.
is change of name.
Yes, the appointment order does not tally, Lordship,
With
with
what?
the PIMS.
PIMS.
Yes, they already got the PIMS and they were receiving the salary.
When they got PIMS was introduced. Ms. Sukri Lanet, Additional Advocate General, Nagaland has submitted that the discrepancies were noticed with regard to the petitioners' names and in the appointment orders and their names incorporated in the PIMS. Full stop. As a result, a process of verification is required. Full stop. Para. Ms. Sukri has submitted, on instruction, that the petitioners okay. On verification, the following discrepancies are noticed.
Yes, yes.
You get it? Affidavit or whatever.
Yes,
Same correction.
Yes, yes.
But since 21.
Do it now. Since
Personally,
21, you are waiting. Do it when
I've
you
been submitted by representation.
No, representation is one thing.
I was never
No.
invited.
Now we are recording it. The details I am recording it. This one, madam, the whole table. Ms. Sukriya's father submitted that once documents clarifying the discrepancy once and one affidavit
We'll find that.
once
Okay.
once an affidavit.
No. They have to change the name duly signed by the first class magistrate because we have already brought a notification, Lordship.
Where is that? Tell me, otherwise they are running helter and skelter. Let us be clear. They again get confused, whatever.
Here it's
Mister, you have this notification.
This is office memorandum dated
Ah.
3rd August.
Do you have this?
Yes, not.
You have. Have you taken steps or not?
I'm not, I do have knowledge about this.
Okay, you have knowledge.
Yes.
Okay. Ms. Sukri has further submitted that the manner in which the procedure in the manner in which the change of name of government employees the manner has submitted that the procedure for change of name of government employees have been laid down in detail in an office memorandum dated 3/8/2023 issued by the Personnel and Administrative Reforms Department, Government of Nagaland. Full stop. It is submitted that once the discrepancies notice above. In case of the petitioners are removed as per the procedure laid down in the office memorandum dated 3/8/2023 by the petitioners themselves. The discrepancies in the PIMS can be sorted out. And the same would also facilitate release of their
Salary.
salaries. Those two. You have this? Mr. Swayanchal, Learned Counsel for the petition, has submitted that he has a copy of the office memorandum dated 3/8/2023. Full stop. Madam, you give a photocopy also.
Yes, yes, I'll give Lordship.
And the petitioners would take necessary steps as per the said office memorandum to sort out the discrepancies mentioned above. Projected by the state respondents. Those two. Having regard to the fact that the petitioners are without salaries since March 2021, if the petitioners comply with the requirements as laid down in office memorandum dated 3/8/2023, then the state respondents shall carry out the necessary exercise for removal of the discrepancies as expeditiously as possible, but within an within an outer limit of 1 month. Once they remove
After we receive all the documents.
that is what.
Yes, okay.
After received, don't raise unnecessary complaint,
Lordship.
grievance. If they go by this procedure, then you carry out entire exercise.
Lordship.
Okay, when you can remove this file an affidavit from the magistrate first class,
Yes.
that my name is this and this is one and the same person. Then you publish short one in the paper. There is a manner, right? Short one you see in every newspaper in the second page, you see a small box. My name is henceforth or Mr. X and Y is one and the same person. Right? So you do the exercise, it has been laid down already. Deed signed by a first class magistrate. But give the format also, madam.
Yes, yes, out.
Give the format also. Otherwise, you'll again raise objection. Because it is said that a deed signed by a first class magistrate, the sample of deed form is enclosed as Annexure 1.
Okay.
Give the form also.
Yes, yes, I'll do. Yes.
Sure. Because I have recorded that he has the copy of the office memorandum.
If he has, he would be having along
I
with
don't know.
the samples also, Lordship.
I don't know.
And it is his duty also to do it.
Help it.
Yes.
Do you have the format?
Right now, I don't have in this. Let's see.
Okay. Ms. Supri shall provide a sample of deed form in Annexure Roman 1, mentioned in the office memorandum dated 3/8/2023 to the Learned Counsel for the petitioner within 2 days from today. List the case.
Lordship, even in the Aadhaar also they have to change. Yes, Aadhaar also.
Then you name a nodal officer. Well, this is I'm not going to do.
Lordship.
Am I here to correct the names?
No, you are not, Lordship, but I'm just saying that.
Then you say that petitioner will approach a nodal officer, name the person.
Mm.
They will approach, he will guide them. Tell me. Every department has a nodal officer who guides the any person who seeks assistance from the department.
Yes, Lordship, it's been 4 years. They should have, since
They
21.
give a nodal
They should
officer.
have. Jimmy,
Otherwise,
They will run for Aadhaar, change of name, all
no,
this.
Lordship, otherwise
please.
that.
Is it not required on the part of a welfare state to provide assistance? So you are a welfare state. They are not getting their salary since March 2001.
Because they are not
Maybe
working.
genuine or ingenuine, whatever. But if there is a process, and you know their work just,
Lordship, during the.
I don't know about their educational
No,
qualification.
yes, Lordship. During the procedure, we have clearly stated that they are not supposed to report for duty. So they are also not reporting for duty, Lordship.
I was informed that they are still discharging their duties.
So, Lordship,
So they are making.
No, I am only saying that. Okay, then I'll issue mandamus now then. Since you are not cooperating with me,
no, Lordship,
in order to assist the petitioners, who is the person?
Also, they are.
No, I
They
try to persuade you, but you are not.
They are making.
The engineer in chief, NPWD, Nagaland, cell, facilitate, appoint a nodal officer from NPWD to assist the petitioners to complete the necessary formalities. Assist the petitioner to guide and complete the necessary formalities.
Lordship,
Since you did not identify, now I have to direct.
Lordship,
I tried to assist both the parties.
Lordship.
You are putting objections everywhere.
No, I'm not putting objection, Lordship. I'm expressing that there are so many anomalies, even in the.
Anomalies, right,
Yes.
right.
Yes.
So they are not assistant engineer or executive engineer or engineering chief.
Lordship,
They are workers fixed pay.
Lordship.
Then somebody, if somebody is to guide, at least that this much document is required,
Lordship.
and these are the anomalies, names, date of birth, appointment order. You need a first class affidavit from magistrate first class.
Yes.
Then you said Aadhaar card. Aadhaar card again is from central government. Something is to be unique identification authority
yes,
of
yes.
India, right? Unique identification authority of India. They issue Aadhaar card.
Lordship,
That somebody should guide them.
yes.
Ultimately, at the end, they are not entirely, it is a different method.
Lordship, yes. Lordship, my
List
apology, yes.
the case on 31st of October.
Lordship. My apology, but Lordship, I feel that you have misunderstood what I'm trying to say. But my apology, Lordship, much obliged.
Orders, item number 15.
Yes, submission was made in item earlier. Last opportunity. Where is Mika HIAF Jimomi? Yes.
Mr. Lordship, Lordship here, I'm appearing for respondent number 4, and Lordship, our affidavit in opposition is under preparation, so kindly grant me 3 weeks more time to file my opposition, Lordship.
No, and who is for the state?
Wow.
Lordship,
Have you read the previous order? V. Jimumi?
Lordship,
he was
can you
here.
grant some time to file affidavit, Lordship?
See, what is the order? What is the order? Have you seen the order? Huh? If no affidavits are filed, this court shall be constrained to pass appropriate directions.
Lordship, in that case, Lordship, some time will be filed, Lordship. It should fight Lordship.
What is the matter about Mr. Pote?
What's your fear? The petition is agreed by the settlement order.
That has been stayed now. That has been stayed.
Yes, we'll see.
Okay, last opportunity. By 17th of October. Right? Possible? Mr. Foseko Fotel, learned counsel for the petitioner. Ms. Pichano, learned government, learned government advocate on behalf of Mr. V. Jimomi, learned government advocate Nagaland, who is handling the brief. Come up for the respondent number 1, 2, 3, 1, 2, and 3. And Ms. Mika H.I., learned counsel for the respondent number 4 are present. First off. The respondents, comma, by the previous order, comma, were directed to file their counter affidavits by the next date of listing. Comma 25/9/2025. No counter affidavit has been filed either by the respondent number 1, 2, and 3 or by the respondent number 4. First off. Ms. I.L. and counsel for the respondent number 4 has submitted that the counter affidavit is on behalf of the respondent number 4 is going to be filed shortly. First off. Ms. Pichano has prayed for further further 3 weeks time to obtain the necessary instruction and to file counter affidavit on behalf of the respondent number 1, 2, and 3. First off. Having regard to the previous order dated 26/8/2025, comma, the respondents are granted one last opportunity to file their counter affidavits within 3 weeks from today. First of lays the case on 17/10/2025. The interim order passed earlier shall continue till the next date of list. Last opportunity.
Item number 16.
Revelation, Lordship. Lordship, as per the last order, 2/9/2025, I was directed to make a fresh notice upon the respondent, private respondent 8 to 11. I have taken the steps and the return service is awaited. So,
Okay, Mr.
Iron Long, Lordship.
Learned counsel for the petitioners,
Yes, Lord.
and Ms. Pichano. Learned government advocate Nagaland for the state respondents are present. First of Mr. Anlong has submitted that he has already taken steps for service of notice among the respondent number 8 to 11 in deference to the order dated 2/9/2025. First of peruse the office note dated 22/9/2025. First of await for the service reports in respect of the respondent number 8 to 11. Full stop. No affidavit, madam. Earlier you prayed for few weeks. Mr. Anangami,
Lordship, yet to receive instruction.
Ms. Pishano, Learned Counsel praying for Mr. Anangami. My senior government advocate has prayed for further few weeks time to obtain necessary instructions and to file a counter-affidavit on behalf of the state respondents. The prayer is allowed. Last to legal is the case after 3 weeks.
Much.
Item number 17.
May please, your worship. As of date, the district administration is making every effort to maintain peace and harmony in the subdivision. Most importantly, peace between these two villages.
What is the matter about?
It's about the changing of railway station from Molwong village to Mezikuma.
Lordship,
So this
kindly
issue.
peruse the last order, your lordship. Paragraph 8, 9.
Let me read the total order, then I understand.
I don't know.
Yes.
My lord, I may be granted 3 weeks time. I have received instruction to. stop
You are
the-
representing whom?
For the state respondents. I have certain clarifications to be.
Who represents respondent number 7?
Motion.
You. Then who represents respondent number 8?
Union.
Then who represents 9 and 10? They were supposed to bring on record.
Yes,
They are not here.
may I pray that 3 weeks time you can. If I-
Oh, because we have to ask them also in their absence, the change in name of the village, change in the procedure of respondent number 9 and 10 railway, then respondent number 4 regarding the award of compensation. They are not here because they were directed to file certain instructions. Yes, Mr. Esther, what we propose is they are not here. Recording their absence, we put it in the next week. Because otherwise they have to be directed also. Heard Miss Esther, learned counsel for the petitioner. Mr. L.T. Sanctum, learned additional advocate general, Nagaland, assisted by Ms.
Busy moment.
P. Jimo, learned senior government advocate,
He's a government.
government advocate.
For.
Nagaland for the respondent number 1 to 6. And Miss Tosi Jamir, learned counsel for the respondent number 7. Full stop. Miss learned counsel for the parties have submitted that the present law and order situation in the area is under control.
Yes.
Full stop. Para. The directions made earlier in the order dated 1/9/2025 to the specifically to the state respondent authorities. Shall continue till the next date of listing. We continue with all this.
Yes.
Para. By the previous order, the respondent number 8 and the respondent number 9 and 10 were directed to bring their stand on record. Post stop. None, and the counsel for the respondent number 9, 8, 9 and 10 are found absent to the on call. Full stop. Mr. Sanctum, appearing for respondent number 4, has submitted that he has not yet received. No, respondent number 4 was directed to file affidavit. Deputy Commissioner, Bharsar Commissioner, has not yet received instructions in reference to the order dated 1/9/2025. Post stop. As the learned counsel for the respondent number 8, 9 and 10 are found absent today on call, this court is of the view that their presence is necessary to to proceed further with the writ petition. Post stop. This case again on. 6th of October.
I don't, after 3 weeks.
No, we are for 8, 9 and 10. We are for 8, 9 and 10. Then you seek time. Their presence is necessary because all this, what is the name? Molvom and Jeep FEMA has been created by maybe the railway authorities. And if change of name is not permitted by Ministry of Home Affairs, then it stops. People have to live with it.
Yes.
Let us have on 6th. And all the interim orders passed earlier regarding maintenance of law and order situation by the commissioner and the deputy commissioner is continued, right? Yeah, price out, right?
Yes.
I have said that it will continue.
Some orders will also state your lordship,
Huh?
so some orders will also state your lordship, so it depends.
That's fine. Along with the interim orders, wherever passed earlier. Shall continue till the next date of this thing, along with the interim orders, wherever passed earlier.
Much obliged.
For motion from the supplementary cost list, item number 25.
Is it-
My pleasure, Lordship. Lordship,
Yes or no, you say simply. Yes or no?
yes, Lordship.
Yes. What is the order? What is the order? Previous order. Yes, Mr. Sopi, you are saying that it is all identical.
Yes, my lord. Yes, my lord.
It would Miss S. Sangmatai, Miss Pichano. For all the for the response number 1 to 6. Paragraph 2. Paragraph 3, repeat করে দিছো, তাতে slightly change করে দিব. The projected case of the petitioner is that initially by an office order dated 30/08/1994. খালি date হয়ে change হবে. The petitioner came to be appointed as a work charged jugali in the pay scale. That is a pay scale. Page 10. Page 10.
Please go.
Come to page 10, sir. In the scale of pay of rupees 800, that's so and so likha ase, page 10, with effect from the date of joining on duty. Poster. Pursuant to the said office order, the petitioner joined his service as a work charge jugali in the establishment of the executive engineer, public works departments, within bracket housing, PHEC, PHEK, PHEC division. Post op. Subsequently, by an office order dated 5/9/1995. The petitioner was transferred and posted at Kohima in the subdivisional office of the PWD within bracket housing. Close to. Officer orderer, paragraph 4. Any representation submitted?
Yes, my lord.
Uh,
Representation dated 20/08/2025.
Para 5 vote. Representation date 2. Annexer E, Page?
Number 17.
17. Particularly, date to change করে দিব 20/08/2025. Paragraph 6, okay. Paragraph 7 not. আপনি লিখিব date to order to mention করে দিব। Paragraph 8, Miss Pichano. Our WBC number, ইয়াতে এইটো change করে দিব। Last paragraph 10 is preferably on or before 31st of March of 31st of today is September, October, November, December. 31st of December.
Lordship, 6 months, Lordship. Lordship, the process of regularizing debt under cost cases. First, it goes to PNF.
Okay, 31st of January 2026.
Okay.
Then you seek time extension by filing an application.
Okay.
Okay, I'll come back.
Obliged, my lords.
Orders, item number 18.
May it please, my lords. I appear through video conferencing. Am I audible to my lords?
Yes.
My lords, at the outset, I fervently apologize for being absent on the last occasion.
Hmm.
As per the Honorable Court's order dated 14/8/25, I had requested my colleague to take steps, and I was informed that steps were taken. However, when I inquired again after producing the order of my lords on the last occasion, I came to know that the steps were taken. However, they were not routed through the registry, and therefore, obviously, the office not reflect that. So I've instructed her to take urgent steps, and it has been informed that the requisite copies were submitted at the registry yesterday.
Hmm.
So, my lord, I apologize for this.
Okay, Mr. A. Borua, Council Court of Petition, has appeared through virtual mode. Full stop. Mr. Boro has submitted that steps for service of notice upon the respondent number 1 and 2 is complete, as extra copies of the writ petition has been served upon the Central Government Council.
My lord, only respondent one.
Or only one. Full stop. He has further submitted that steps for service of notice upon the respondent number 2, 3, and 4 have been taken recently. Full stop. Peruse the office note dated 24/9/2025. Full stop. The office note dated 24/9/2025 reflects that steps for service of notice has been taken by the petitioner on 24/9/2025. Full stop. In view of the above, await for the service reports in respect of the respondent number 2, 3, and 4. Lays the case after 4 weeks.
I'm so obliged, my lords.
For hearing, item number 19.
Lordship, may I plead?
Yes.
Lordship, here the issue is very simple. Regarding that, I was first granted patta, and accordingly, later on, the state respondents, they have cancelled my patta. So here, in this case, your Lordship, I have agreed by the impugned order dated 3/6/2021, passed by the respondent number 3, that is Deputy Commissioner, in pursuance of the order passed by the respondent number 4, that is Revenue Officer. So here,
3/6/2000, where is that order? 3/6.
that is page 20, your Lordship.
Is 20.
Yes, Lordship.
And what is 13/5/2021?
Lordship, that is this respondent number for Revenue Officer. After conducting survey, it was found that I'm not the original owner, though it was already patta was issued in my name on the recommendation of respondent number 4, that is Revenue Officer. This respondent number
Where is
2
that
was,
13/5? Where is that 13/5?
Lordship. That is page number 22, Your Lordship.
Page number?
22, Your Lordship.
This order, page 22,
Lordship,
was an ex parte order or intra parte order?
Lordship, as per the state government's reply, they have stated specifically that at that time when this hearing was taken place, I was taking care of my mother at Assam, Nagaon, and they have sent that notice to one of my representative, which was not in my knowledge. And they have also pleaded that my representative were present on that particular date when this hearing was taken place. But your lordship, it was not informed to me. Here in this petition, I am only seeking this honorable court's permission that I may be given an opportunity of being heard before a cancellation of my pata, your lordship. No doubt, as per the claim of the state respondents, they are saying that my representative was there, but it was not authorized by me, your lordship. And my representative also didn't inform me about this outcome. So I'm only seeking little relief from this honorable court that
Therefrom, you can observe so that you did not authorize your authorized representative. Wherefrom we can find all those.
lordship. So here, lordship, I'm also
looks
saying
like,
that
it looks like this copy was forwarded to you, and it reflects that on hearing the matter, summons were parties were given ample opportunity to present its case. Also submit any documents in their support.
lordship, that is what
On hearing the matter, so it appears to be an intra-party order, not ex-parte order.
Lordship, that is what I am saying. I was not physically present, your lordship, on the date when this final hearing was taken place, your lordship. And state respondents, they have also enclosed along with their affidavit in application that
Counsel, Mr. Suryan,
lordship.
if had it been a case of no opportunity, no notice, no hearing, I could have understood.
Lordship.
But here is not a case that no notice, no opportunity, no hearing. It looks like that opportunities were granted, notice were served, and you were heard. And you doesn't mean that you only, your authorized representative can also be heard in your place. So
That is what lordship, that is what I am saying that.
And that is page 20 is a consequential order only.
Lordship. And lordship,
what is the procedure in case such an order is passed under the land and revenue regulation?
lordship. And your lordship, as per land and revenue regulation, only commissioner has power to revoke once any pata has been issued under the act. But in my case, this pata has been cancelled by the deputy commissioner, who has not authorized under this act. And this land and revenue act is applicable even in Nagaland also, your lordship. Rule 26 clearly says that only commissioner has the power to cancel my pata. And in this case, the approval of the government has not been taken. But my pata has been cancelled by the deputy commissioner only, your lordship.
If any order passed by the revenue settlement officer or by the deputy commissioner, is there any appellate authority under the land and revenue regulation?
No, as per lordship, my pata has been cancelled under land and regulation, and that same act, rules 26 says that only commissioner has the power to cancel pata. So if state government is applying that principle to cancel,
why you are not answering my question?
lordship.
Have you heard my question, or you on your own making submission?
Lordship, yes. After that, your lordship, definitely.
When an order is passed by a revenue settlement officer or a deputy commissioner in exercise of power, rightly or wrongly, under the land and revenue regulation, is there any appellate authority to challenge the order?
No, your lordship. There is no such appellate authority, but the power has only been given to the commissioner.
But
Under
I
that,
don't add anything. I am asking simple question. I am asking a simple question which can be answered in yes or no, not in 10 sentences. I'll ask later on subsequent question, then you answer.
Lordship.
Yes, is there any appellate authority?
Lordship, as per the Assam Land Regulation 86, Commissioner, there is an appellate authority under the land legislation. So most likely the commissioner, I'm not so clear, but commissioner will be the highest authority. So whatever be the order passed by the officer concerning the district or district collector or revenue officer, if the party feel aggrieved, they have ample liberty to go to the appellate authority.
Is there any appellate authority? He's saying no.
I think there is an appellate authority.
You saying yes.
And so long as that Assam Land Regulation 1886 is applies in the district of Dimapur, sir, we go by that.
This is a matter from Dimapur.
Yes. And this is purely Dimapur, and Dimapur is the only civilian in the state of Nagaland.
Is there any board of revenue in the state of Nagaland?
No board of revenue is not yet to consider. But as far as the revenue jurisdiction is concerned, the district highest authority of district collector, and above in the state level there is a revenue authority. So whoever aggrieved by the action of the district collector or the revenue officer, then the party has other remedy to go under the same provision of law. But your lordship, here in the present case, here wherever we go, we need to medium of transportation. So medium of transportation in the case of litigation is a procedure. Procedure. Now in the present case, the petitioner, here the petition is suffering from non-jointer parties because the land belongs to the veterinary department. So director cannot represent the veterinary department. And again, the petitioner purported to have purchased the land from another person. He is also a necessary party in the present case. He was not implicated as a respondent. Again, over and above, your lordship, these are pertaining to land matters. So the revenue authority, land and revenue department should have completed as a necessary party in the present petition. So those are the crux of the petition, and without which we cannot proceed under the provision of law. So the petition is suffering from serious misconduct of the necessary party. And if any decision, any direction is given by the honorable court, then director cannot do anything unless the department is implemented as a respondent. Otherwise, the merit of the case, we have a strong case, merit of the case from the inception of the statute, we have an occupied land more than 50 years. The veterinary department, we have an occupied.
Some disputed questions of fact also.
So
these are fact finding. These are fact finding thing.
Yes. Now the main is procedure. When the necessary party is not implemented, then how to give direction to the parties? That's a problem. When the private respondent is involved, then in that case, he is a necessary party under the provision of law. But whereas here it is not implemented.
Who is the necessary party?
One. So the petitioner, he is taking a scheme that he purchased a plot of land from that lota, but he is not implemented as a respondent in the present case. But over and above, the government cannot be represented by one director. The government cannot be represented by director. Those are the major effects, and that's the crux of the case.
Chief Secretary is made a party.
Yeah, but chief secretary is by application is the parties, but the concerned department, because the veterinary department land that's under dispute. It is under attack, so it has to be brought to the knowledge of the secretary of the department. So that's the crux, without which we cannot proceed.
May I plead your lordship?
Mr. Suryan, we know that section 26 has given power to the commissioner. But final mutation order, he has cancelled.
Lordship,
A revenue and settlement officer.
Lordship,
And allotment order
Lordship,
issued to Mr. Foidemo Lotha,
Yes.
Lordship,
right?
Lordship,
Now, your right is connected with this Lotha,
Lordship,
and Lotha is not a party
Lordship,
in this proceeding.
Lordship,
And his allotment has been cancelled for whatever reason. He is not aggrieved.
Lordship,
Your right of possessing that land is born out of Lotha.
Yes.
Lordship,
So think it over. Final mutation, he has the power, except cancellation of patta,
Lordship,
right? So
Yes.
entire order is not suffering from lack of jurisdiction. You see page 24, he took 3 steps. One is cancellation of final mutation. It was granted in whose favor?
That Pajama Lotha, Lordship.
Lotha.
Yes, Lordship.
Then second one, patta. It was issued to you.
Yes, Lordship,
And thirdly, the allotment order issued to Lotha.
Lordship,
2, yes, 2 may be due to lack of jurisdiction, you may have a case.
Lordship,
But 1 and 3, this authority might have the power to cancel mutation.
Lordship,
Mutation is for the purpose of what? For the purpose of collecting revenue.
Lordship,
And a settlement officer is perhaps empowered to cancel mutation.
Lordship,
If you go through section 52, 53, 54,
Lordship,
Registration.
registration,
Yes.
he has the power after hearing.
Lordship,
And page 20 is a consequential order by the Deputy Commissioner. He has said that appropriate authorities shall proceed for cancellation.
Lordship,
And the Deputy Commissioner has passed an order.
Lordship,
I think this for the first step and third step,
Lordship,
this Lotha has to be on record as a party.
Yeah, without Lotha, the petitioner
And
cannot
plus-
jump.
And you are claiming against a veterinary department. Think it over. Think it over. I may not be, yes, you have made out a case under section 26. But for the other 2, you may not have a case. That is why I asked whether it was a intra-party or ex-parte. Ex-parte definitely could have been, you could have been given an opportunity of hearing. Again, your limited prayer was that, no?
Lordship.
Not.
And
So once it is done, how can they again be? It should be before the appellate authority. And you are not sure whether you said no, he says yes.
No, Lordship, actually, why I said so, because in that Assam Land Revenue Regulation, there was this appellate authority, that word was not there. Only power was given to the commissioner. In that,
What is section 147 in your land and revenue regulation? What is section 147? I don't know. I am aware of Assam Land and Revenue Regulation. So what is section 147?
there is,
You have the land and regulation.
yes, yes. And there is appellate authority, but with regard to when there is any dispute regarding whether the concerned authority will issue or give law to me or not. That provision is there, Your Lordship. But not with regard to cancellation of patta, Your Lordship.
Otherwise, section 147 says that appeals shall lie under the regulation as follows: to the Board of Revenue from orders, original or appellate, passed by the Deputy Commissioner and the settlement officer or survey officer within 2 months from the date of the order. Right?
Lordship.
So, regulation says there is an appeal provision. I don't know about the state of Nagaland. Because if we find this kind of petition, we don't normally relegate
Yes.
the petitioner to the Board of Revenue.
Yes.
You go first,
Yes.
Board of Revenue. Why you are coming before this court under 226? I don't know about the state of Nagaland. Whether you have the
Lordship, that provision is there, but physically it's not there, Your Lordship. No doubt. Under this regulation, there is a provision, but physically we don't have such board here in Nagaland, Your Lordship.
and if cancellation of registration is under section 50 onwards, right?
Lordship.
I know about 26. But this is a serious issue regarding to make
Lordship.
any challenge to this page order which were passed against Lotha. How can you step into the shoes without him as in the area of parties?
Lordship, in that case,
Think
if
it
this
over. I'll just record the submission of Mr. Im Chong, that non-joiner party. You think it over.
Lordship, in that case, if this honorable court considers that this particular letter from whom I have bought the land, he should be a party, then I'm seeking liberty of this honorable court.
You think it over. I am giving you liberty to
I may
think
be
over.
allowed to add
To
him in
think
this
over.
petition
You
as a
file
party.
an application thereafter we think. I had Mr. P. Shurian,
Lordship.
Harshal Mood, and Mr. Im Chong, Learned Additional Advocate General, Nagaland, for the state respondents post of Mr. Im Chong has raised a issue of non-joiner of necessary parties having regard to the order dated, impugn order dated 13/5/2021 within bracket Annexure B. Post of it is his submission that the land, a plot of land in dispute has been claimed by the veterinary department. So the ownership of the plot of land in dispute
Your Lordship,
has also been claimed.
actually, it is not claimed by the department. It was a department land and it was illegally allotted to the Mr. Lota. That's a story.
Okay. He has submitted that the veterinary department and one Lotha, one Sri PHYODEMO Lotha should have been arrayed as party respondents in the instant repetition. First of para Mr. Suryan Learned Counsel for a petition has sought a week's time in order to complete his instructions. Let the case be listed again after a week. Think it over.
Lordship.
You are enjoying any interim order?
No, Your Lordship. Obliged, Lordship.
For hearing, item number 24. My please, Your Lordship, I'm mentioning on behalf of Cynthia, Your Lordship.
In Sandy Anger, yes.
Your Lordship. Lordship, he was here this morning, however, Lordship, due to some personal emergency work, he has to leave, Lordship. So I have an instruction to pray the listed matter after break, Lordship. Right after puja break, Lordship.
Yes, you are there. Mr. Paki Richambo. Pakin Richabo. Learned Counsel for Petitioner, Mr. Im Chung, Additional Advocate General for the state respondents are present. Mr.
Noklay and Punyak, on behalf of Cynthia.
Boniak, okay. Has made a pay on behalf of Mr. Senti Iyengar, Learned Counsel for the respondent number 2, 3, 6, and 7. That Mr. Senti Iyengar, due to personal difficulty, emergent personal difficulty, has to leave the court today. So he has, Mr. Poniak has therefore submitted that the case be listed on another date after a week. Also, yes. As the Learned Counsel for the other sides have expressed no objection to the prayer submit, the matter stands adjourned for a week, list the case after a week, on a date to be expired hours.
Deeply obliged. For motion from the supplementary course list, item number 27.
With this one, Lordship. Lordship, it's just that, that RTI dated 10.
RTI Act.
Yes, that is annexure A page 11. This was filed by one.
Okay. RTI Act, right to information.
Yes. Seeking the information of the petitioner's lordship. That is 8 in numbers. Shall I read out or will it be okay, lordship?
Okay,
Okay.
but where is the notice? On that one,
Then-
urgent notice on.
In pursuant to it, targeting the petitioner's lordship, just because they filed.
That we're not going to do.
Yes.
We are not going to do.
Yes.
We are simply in RTI provisions,
Lordship.
Act provision, that I have clearly mentioned.
Yes, yes.
Because what is the definition? What is the right? Any person can make an application under RTI Act
Yes, yes.
seeking public information. So there is no bar. That question of vengeance is out of picture.
Lordship.
RTI Act.
Yes, it's up to the public authority to accept or reject. So in pursuant to this,
Applications are made. Seeking
yes, Lordship, I admit.
educational
Of course.
qualification of the Honorable Prime Minister.
Of course.
So you are not immune from that. 1 minute, let me have.
And I thought, Lordship, this 2023 amendment came into effect
He
because
is-
of that.
Our Honorable Prime Minister is also facing the same issue.
But it is not provided, Lordship.
But that is a different issue.
Yes, in
But-
pursuant to that,
But nobody can stop.
yes. Lordship, I admit.
So you cannot pray for injunction against the applicant.
No, that I am not, I'm seeking. I'm not seeking.
Yeah. What happened? That's the act.
So
Heart, yes.
page 16, B, I'm only on that.
But my submission is the prayer of the petitioner, it comes within the permission of the statute provision.
Right.
That's the only thing,
We are not here to do so.
yes.
they have made out a privacy case in the sense that these are personal information. Marks are personal information.
Yes.
Educational qualification, yes. It is not personal information if he is an employee. But he is also asking for mark sheets. We are not going into that aspect.
Lordship.
We are only that an applicant that is section 6, I think. Section 3. Subject to the provisions of this act, all citizens shall have the right to information. So there is no bar.
Lordship.
And obligation of the public authorities that they have to provide the information. Now, every office should have a public information officer. Then section 6, a person who desires to obtain any information shall make a request in writing. That has been done.
Section 8.
Right. Now section 8.
Exemption.
Exemption. If it is, say, 81J, information which relates to personal information.
Yes.
Right. Now, section 11, third party information.
Yes, Lordship. And as my Lordship in your wisdom knows that they have to.
They have to put on notice.
Yes, yes.
Right.
Yes.
That whether it is they want to keep it confidential or not. Then if they say that they claim immunity, that don't disclose, then under subsection 2 of section 8, the public authority can still allow, but before that, the person should be given notice.
So that's
right. Now, whether this public information officer has exercised the power to disclose the third party information or personal information, rightly or wrongly, that can be made a subject matter of appeal, and which they can prefer under section 19. But since they have said that no notice, so I'll allow them to prefer an appeal.
yes. Just
Without going into the merits. And till that time, the appellate authority considers it that information directed to be disclosed should not be disclosed.
that's all.
That is all. We are not entering into hard. Miss Jet Zimomi, Jet, right?
Z.
Because Z-A-V, learned counsel for the petitioners, and Mr. Im Chong, learned additional advocate general Nagaland for all the respondents. The petitioners, 6 in number, have joined together to institute the present writ petition to assail and urgent notice, U capital and capital, dated 19/9/2025, issued by the principal director, Department of School Education, Nagaland, within bracket, respondent number 4. Full stop. By the urgent notice dated 19/9/2025, comma, the respondent number 4 has directed, page 16, district controlling officers within bracket DEO Dimapur up to so and so bracket close to take immediate necessary action in notifying the teachers serving under their establishment to furnish the required documents listed in annexure thereto without delay to their respective district officers for timely submission to the Directorate Office, Post Office. In annexure 1 to the urgent notice, but you were asked to provide the documents, is it not?
Lordship.
By this notice.
Yes, yes, yes. By yesterday.
Did you put objection? No. Okay. Leacock, note in annexure 1 to the urgent notice, comma, a list of teachers along with their details has been
Listed out at the next year.
along with their details has been provided. Post of by the urgent notice, comma, the last date for submission of the required documents to the Directorate Office has been fixed as 24/9/2025. Post of para. The petitioners have stated that their names have figured in annexure Roman 1 to the urgent notice dated 19/9/2025. Post of. In annexure 2, or Roman 1 was numerical 1. In annexure 2, in annexure 2, comma, the list of documents which are to be submitted are mentioned. So they are page 18, 1, 2, 3, 4, 5, 6, 7. It is contended on behalf of the petition that an applicant submitted an application before the public information officer O/O, the Directorate of Education, Nagaland, Kohima, seeking certain information under the Right to Information Act. Post of. In the application, the applicant has sought various details of 47 number of teachers post of. Among the information sought, comma, the academic qualifications and marks obtained by those teachers are included. Post of. The applicant has also sought the appointment orders, comma, regularization orders, etc. of those 47 number of teachers. Post of. The names of the 6 petitioners herein are among those 47 number of teachers whose information, whose Pustak, it is further contended that the information sought by the applicant in his application under Section 6 of the RTI Act and the information sought to be disclosed by the respondent number 4, comma, as evident from Annexure 2 to the impugn urgent notice, comma, are personal information. Full stop. It is, comma, thus contended that the respondent number 4 is contemplating to disclose the information comma, which is protected under Section 81J of the RTI Act.
Lordship,
Okay, not required. Then this has to be director has to hear you. Not required. He will hear you.
just one small clarification for myself also. Under 6 requests for obtaining information, 3, clause 3, whether that is applicable to the petitioners, that's all, Lordship. 3, where an application is made to a public authority requesting for an information, Roman 1, which is held by another public authority. So we are not public authority, the petitioners, as per the RTI Act. That is my humble submission before the Honorable Court.
So we don't think that a director should hear you. Not required to be to approach, because he has directed you to submit those documents, which according to you is your personal information.
Yes, personal information, and we are not public authority, the petitioner, so as per
Arguna matter, thereafter you prefer appeal. You Arguna matter, will stay this.
Yes,
Notice
yes.
that before directing
Yes.
the petitioners to submit those documents, the respondent number 4 should pass a speaking order as to whether these are personal information.
Exactly.
First of Mr. Imsong Larat, Additional Advocate General Nagaland, has submitted that by the urgent notice dated 19/9/2024, the respondent number 4 has merely asked for submission of the documents, and as such, the same cannot be termed as violation of the rights of the petition. Para. Having regard to the nature of contentions raised, this court is of the view that instead of keeping this writ petition pending, this writ petition can be disposed of at the motion stage itself as consented to by the learned counsel for the parties. Para. It is under subsection 1 of section 6,
2 also, Lordship.
Oh, 1 minute. Don't disrupt my flow.
Lordship.
A person, who desires to obtain any information under the RTI Act, shall make a request in writing or through electronic means in English or Hindi or in any official language of the area in which the application is being made, accompanying such fee as may be prescribed, to the central public information officer or state public information officer, within brackets CPIO and SPIO, as the case may be, of the concerned public authority, specifying the particulars of the information sought for by him or her. Full stop. As per section 6(2), an applicant making the request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. Posted. We will not venture into subsection 3 because as an employer, they can definitely ask for your mark sheets. But question is about disclosure to some other parties.
Yes. That is it. If it is within the department, that
Yes, he can obtain
yes,
your information.
it's already in
Right?
there.
Even if it is absent in their custody, he can definitely ask. But question is about disclosure to.
Yes, exactly.
That is what, right? We are only into that.
Yes.
The definition of quote unquote information has been provided in section 2 small f of the RTI Act. Full stop. Para. Section, as the para, section 3 has provided that all citizens shall have the right to information, subject to the provisions of the RTI Act. Para. Section 7 of the RTI Act has provided for the time limit within which the information is to be furnished to an applicant. Section 8 of the RT Act, which is, subsection 1 of Section 8. Oh, sorry, Section 8 as provided for exemption from disclosure of information. First of subsection 1 of Section 8, which is with a non-obstante clause, has inter alia provided that there shall be no obligation to give any citizen information which relates to personal information. Subsection 1 small j bracket of it. It is the case of the petitioners that since by the impugned notice, the respondent number 4 has clearly disclosed that the information, the documents he has sought for, as outlined in Annexure 2 thereto, are to be provided to the applicant, who has sought these information in his application made under Section 6 of the RTI Act. Therefore, before taking any such decision, the petitioner ought to have been heard by the respondent number 4, as no opportunity has been granted to the petitioners before taking the decision to call for the documents and also to disclose the information pertaining to those documents to the applicant, the decision taken by the respondent number 4 to disclose the information calls for an interference. Para. This is your case?
Yes, Lordship.
Section 11 of the RTA Act pertains to third-party information. The petitioners have claimed their right under Section 11 of the RTA Act. As per subsection 1 of Section 11, where a CPIO or a SPIO, as the case may be, intends to disclose any information or record, or part thereof on a request made under the RTI Act, which relates to or has been supplied by a third party and has been treated as confidential by that third party, the CPIO or the SPIO, as the case may be, shall, within 5 days from the receipt of the request, give a written notice to such third party of the request and of the fact that the CPIO or the SPIO, as the case may be, intends to disclose the information or record, or part thereof, and invite the third party to make a submission in writing or orally, regarding whether the information should be disclosed, and such submission of the third party shall be kept in view while taking a decision about disclosure of information. Full stop. As per subsection 2 of section 8, where a notice is served by the CPIO or the SPIO, as the case may be, under subsection 1 to a third party in respect of any information or record or part thereof, the third party shall, within 10 days from the date of receipt of such notice, be given the opportunity to make representation against the proposed disclosure. Question. Para. It is the CPIO or the SPIO, as the case may be, has the authority and jurisdiction under section 6 within bracket 2 to allow access to information, if public interest in disclosure outweighs the harm to the protected interest. Para. The sum of the documents, it is true that the respondent number 4, as an employer of the petitioner, can ask for the required documents as listed in Annexure 2 thereof. But the question asking the employees to submit the documents by the employer, like the respondent number 4, like the petitioners and the respondent number 4 herein, is quite different from asking the information, which are, some of which are personal information, some of which are prima facie personal information, for disclosure to third party, like an applicant, is a different matter. Full stop. If the respondent number 4, as the respondent number 4, by the impugned in urgent notice dated 19/9/2025 has expressly has intended to obtain the information and the documents listed in Annexure 2 for disclosure to third party, the respondent number 4 ought to have given notice to the persons, including the petitioner's hearing, whose personal information he has sought to disclose. Full stop. Para. The provisions of Section 11 within bracket 1 in such view of the matter, the respondent of 4 ought to have taken recourse to the provisions contained in Section 11 within bracket 1, Section 11 of the RTI Act. Full stop. Since the procedure laid down in Section 11 of the RTI Act appear to have not been adhered to, this court is of the view that the respondent number 4 must adhere to the procedure laid down in Section 11 of the RTI Act before full stop. By putting at first, the persons, by putting at first the persons, the petitioners at notice in terms of Section 11, in terms of the procedure, in terms of the statutory procedure, asking for their providing them the opportunity to make representation against the proposed disclosure. Post having regard to the fact situation, above fact situation obtaining the case, this court, without going into the merits of the claims regarding claims whether all the entire informations are whether whether the documents, information and documents sought to be disclosed sought to be information listed mentioned in Annex 2 to the urgent notice of whether or not, without going into the merits of the claim, whether or not the information and the documents sought for as listed in Annex 2 to the urgent notice, this court is of the considered view that this writ petition can be disposed of, directing the respondent number 2 to strictly adhere to the procedure laid down in Section 11 of the RTI Act, and thereafter to take a decision in terms of Section 8 within bracket 2 of the RTI. Full stop. It is further observed that without adherence to the procedure laid down in Section 6 and without taking a decision under Section 8(2), the respondent number 4 shall not take any decision to disclose the information post. But we are not stopping submission of your documents. That he can, as an employer, he can do. Full stop. As the petitioners have approached this court, assailing the urgent notice dated 19/9/2025, this court, to expedite the matter, observes that the petitioners treating the urgent notice as a notice under Section 8(1), shall submit their representations within 10 days from today, as per Act only, 10 days from today, showing reasons as to why the proposed disclosure should not be made. First of, with the above observations, made above and directions, observations made and the directions given above, the writ petition stands disposable.
Highly obliged.
Covered? Everything covered?
Lordship.
Because we have to expedite also.
Yes, Lordship.
You know now, you have the knowledge. You give the representation.
Yes.
Somewhere I also said all the persons including the petition.
Lordship.
Meaning that
It will be submitted to the first appellate authority.
no. Director, I am keeping one more option open. If director passes an order under section 8(2), then you have the right to appeal, first appeal.
First appeal to the respondent number 4.
No, whoever is. You
yes.
exercise. 19(1), 19(1).
Yes, this will be before the SBI.
So you have three opportunities now.
Lordship.
One before director,
SBIO.
then second is first appellate authority, third is information commission.
Information Commission. That-
Thereafter
yes.
Supreme Court.
Highly obliged, Lordship.